What is a springing or enduring power of attorney? Most Canadians know that they should have a power of attorney for property and personal care. Far fewer are clear on how exactly that works, or that there's more than one way to set it up. You might be wondering, should my power of attorney be a springing or enduring? Let's walk through that clearly, without the legal fog. So what is a power of attorney? At its core, a power of attorney lets someone you trust step in to make decisions if you cannot. This might mean paying for bills, dealing with banks, or healthcare initiatives while you're unable or unwell. In Canada, there are two common approaches to when that authority starts: a springing power of attorney and an enduring power of attorney. The difference matters more than most people realize. So a springing power of attorney only takes effect after a specific trigger, usually a formal determination that you've lost mental capacity. Until that moment, your attorney has no authority at all. On paper, this feels reassuring. You stay fully in control unless something clearly goes wrong. But that protection also comes with a trade-off, and it often shows up at the worst time possible, when you need it the most. An enduring power of attorney takes effect as soon as it's signed, and it continues if you later lose capacity. That doesn't mean you give up control right now. As long as you're capable, you're still the one making your own decisions. What it does mean is that if help is suddenly needed, your chosen person can step in right away without delays, assessment, or friction with any institutions. For most families, that means it can speed up the flexibility more than you expect. So how do I decide which approach fits my life? We usually encourage clients to think about three things. First, how comfortable are you with dealing with delays? Springing power of attorneys can create real bottlenecks, especially with banks, when your family needs things to run smoothly. Second, do you truly trust the person that you've chosen? If yes, an enduring power of attorney with clear safeguards is often a more practical option. If no, well, if you can't trust someone when you have capacity, you're going to be in for real problems if you don't have capacity. Third, how complex is your financial world? Do you have business interests, multiple accounts, or dependents? It usually means that fewer roadblocks is better than more. At Clarified Wealth, we don't believe in one-size-fits-all answers, but in many real-world situations, an enduring power of attorney with strong guardrails causes fewer problems than a springing document that looks protective on paper. And to be clear, I'm a financial planner. I'm not a lawyer, so always get proper legal advice and make sure that your documents match your situation and your preferences. If this is something that you've been putting off, that's normal. But getting it right can remove quite a lot of stress for you and for the people who count on you.